trust that you are doing well and that you are busy studying for your exam. Today's session is just going to be a brief summary on study unit 17, which is life partnerships. Currently, there is no legislation that gives legal recognition to cohabitation relationships, also known as life partnerships. Although this is the position, there are certain benefits that have been given to cohabitants by the courts. The cohabitants are the life partners. It is important to note that since the publication of your prescribed textbook, the South African Family Law, there have been legal developments that have altered the legal status of both heterosexual and same-sex life partners. And this is because of court rulings. Some of the court rulings are in the case of Pacho versus the Road Accident Fund. Here it was held that the dependence action in the dependence action claim, the plaintiff must prove that they had a legally enforceable right to claim maintenance from the deceased. The Supreme Court of Appeal in this case held that the deceased had indeed a legally enforceable duty of support from the deceased. This is because the parties had entered into a tacit contract of reciprocal support, which the court inferred, or which the court made a ruling that the parties had a tacit contract based on the couple's conduct and how they conducted themselves during their relationship and the surrounding circumstances. For example, the surrounding circumstances can be how did the family members regard them, how did the friends regard them, did they regard them like only as girlfriend and boyfriend, or did they regard them as a couple almost in a similar marriage-like relationship. So it is important to note that tacit contract can bring rise to life partnerships, and to prove that the court will have a look at the conduct of the parties, how the family members and friends regarded the couple, and whether there was a reciprocal duty of support between the parties. The second case is Duplessis versus the Road Accident Fund. In this case, the common law action by a spouse for loss of support against the wrongdoer who unlawfully kills the other spouse was widened or was extended to include partners in a same-sex permanent life relationship, which is similar to that of a marriage. And again, just like the first case, the partner in this case was successful because she was able to prove that there was a tacit contract that was entered into between the parties, and that tacit contract resulted in a reciprocal duty of support between the parties. The third case is Gori versus Golfer. Here, the Constitutional Court ruled that the partners in a permanent same-sex life partnership should be regarded as spouses for the purpose of the Interstate Succession Act. For the purpose of the Interstate Succession Act. Now, recently, in the year 2022, the Constitutional Court made a landmark ruling in the case of Buanya versus the Master of the High Court. Here, the Constitutional Court declared that Section 1, Subsection 1 of the Interstate Succession Act is invalid and unconstitutional because it excluded life partners in a permanent opposite relationship from the definition of a spouse. It ordered that Section 1 of the Interstate Succession Act be read to include a partner in a permanent life partnership in which the partners have undertaken a reciprocal duty of support. You will note that in your prescribed textbook, most of the cases that are spoken about there where life partners or cohabitants have been given a right or benefit, almost all the cases is about same-sex life partners. So the Boanya case is different because this does not involve same-sex partners, but heterosex or opposite sex. It was an opposite sex relationship. So this is a landmark case that has now actually brought the position of same-sex life partners and opposite life partners on an equal basis. Further to what I'm back now to the Bonya case, further to what the Constitutional Court has ruled on, the Constitutional Court declared Section 1 of the Maintenance of Surviving Spouses Act unconstitutional in that the definition of the word survivor excludes the words, excluded the words and includes the excluded parties in a opposite relationship, life partnership, a relationship, and the Constitutional Court ruled that the words ruled that the surviving part of a permanent life partnership must be included. In other words, the Constitutional Court ruled that the word survivor must include a partner in an opposite life partnership or an opposite cohabitation relationship. But to succeed, the partners must prove that they had undertaken a reciprocal duty of support and that the circumstances of the relationship prove that the parties were in a cohabitation, which is a cohabitation or a life partnership relationship, which is similar to that of a marriage, and that the respective friends and family members took the parties as being in such a relationship, which is marriage-like. The next case is Labuscha versus Duplan. Here, the Constitutional Court extended the benefits under the Interstate Succession Act to partners in a permanent same-sex life partnership in which the partners have undertaken a reciprocal duty of support. Students, it is important to know that for a relationship to be declared to be a life partnership or a cohabitation relationship, the parties must have a reciprocal duty of support. In other words, the parties must have agreed to financially support each other or to provide support each other if it's not financially to undertake it. Let's say there's a woman or the female partner who has agreed that I am not going to work and my role in the relationship will be to look after the children, to look after the household, to look after the partner, like in a similar role that is taken by a housewife. And then the other party will provide the financial support. It is very, very important that you know that every cohabitation or a life partnership relationship, there must be a reciprocal duty of support. If there is no reciprocal duty of support, then that relationship cannot be declared to be a life partnership. Recently, in March 2023, there is a court judgment which was made by the Gauteng Division of the High Court in Pretoria in the case of G versus Minister of Home Affairs, or Greyland versus Minister of Home Affairs, where they declared that Section 7, subsection A, Section 7, subsection 3, subsection A of the Divorce Act is inconsistent with the Constitution and invalid to the extent that it limits the court's discretion to redistribute property on divorce to. Okay, I'm sorry about that. this case, G versus Minister of Home Affairs, does not belong here. I apologize, student. I included the case by mistake. Please just ignore the information that I've just said now about G versus Minister of Home Affairs. That case has nothing to do with life partnerships. I apologize for that, student. For the other cases, student, please read your prescribed textbook, especially for the purposes of the exam. For the purposes of practicing, once you start practicing as an attorney or as a legal practitioner, please note the Buanya case. It is a very, very important case. And also note the other cases which relate to same-sex, life partners. Now, partners or life partners have an option of deciding to enter into other means to protect themselves. The first one is through a contract. Partners can enter into a partnership agreement, but out there is commonly called cohabitation agreement. The second option that partners have is a universal partnership. Please make sure that you understand what a universal partnership is, and you make sure that you understand what the requirements of a universal partnership is. Information about universal partnership can be found on page 257 to up until 200, and it's quite a comprehensive section up until 268. So please make sure that you thoroughly study and understand what a universal partnership is, because in practice or in the court, most partners in a cohabitation relationship, they usually bring court applications to have the relationship declared a universal partnership. You also need to understand that there's a difference between a cohabitation relationship, life partnership relationship, and a universal partnership. So please make sure that you also understand what the difference is. And also, students, study the other options that the protection by means of ordinary rules, the other options that parties have, which is agency, estoppel, will, and unjustified enrichment. This information can be found on page 260, and it's just brief information. Study Unit 17 comprises a lot about universal partnership and, again, heterosexual life partnership and homosexual life partnership. But as I stated, please note that there have been legal developments, because the Buanya case, you will not find it in the prescribed textbook because it is a recent judgment. But please study the tutorial letters, especially tutorial letter 102, where we have summarized all the latest legal development brought by court judgment. That is where you're going to find what is the current position now. Student, if you need any clarity, please feel free to send me an email on monarkn, monarkn @unisa.ac.za. Students, again, I want to say, when you study, the first thing you need to do is study to understand. Make sure that you understand. And for example, you understand what cohabitation is, what universal partnership is. That will make it easy for you, that when you study now again for the exam, it's going to make it easy, because you will now have a basic understanding what the subject that you are studying at the time is about. Good luck, students, and all the best with your study.